Thanks. Thank you, everyone, for joining us. This Financial Poise webinar, Negotiating an M&A Deal, is part of the Private Company M&A Bootcamp 2024 series and is sponsored by Sunburst Digital, Mood, and Max Asset. Slides 7 and 9 of the PowerPoint summarizes this episode and the 2024 Bootcamp series. This, in fact, is episode number 5, so it is the last of the series. Thanks if you've participated in all of them. Speaking of the slides, we're not going to step through the PowerPoint in any kind of order, or we could typically we don't refer to them a lot, but I'll click on a few things as applicable. This webinar, like all Financial Poise webinars, is an informal conversation. You can keep the PowerPoint handy if you want to follow along, if you've printed it out, or to take notes. But for the general matter, I think you should just be sitting next to us on this fireside chat about negotiating an M&A deal. Our panelists are, and we're joined today by Bob Decker. Bob is a career capital markets professional, operating executive with extensive experience working with companies ranging from emerging growth to large publicly traded companies. He specializes in developing and implementing creative capital formation strategies and advising clients on alternative approaches for maximizing shareholder value in connection with mergers and acquisition activities. Tom Goldblatt is with us today. Tom founded Ravinia Capital, which is an investment bank, in 1998 and serves as managing director. Businesses hire Ravinia Capital to sell companies, raise senior debt, junior capital, and equity, also to advise sellers and buyers of businesses, and to structure transactions, execute, and close them as well. Tom specializes in getting deals done and in developing creative solutions for transactions. Michael Weiss is with us today. Michael's a principal of Weiss Bernie LLC, which is a boutique corporate and real estate transaction law firm in the Chicago metropolitan area. As a transactional legal veteran, Michael represents privately and publicly held entities and businesses in commercial transactions. He also handles the negotiation and closing of complex corporate and commercial real estate transactions, both domestically and internationally. He's also a certified public accountant, and his experience includes all aspects of mergers and acquisitions, securities, and corporate governance. And rounding out today's dream team, we have Jeremy Weitzman. Jeremy is a partner at the Chicago full-service law firm of Mudd Shalist. Having trained as an M&A attorney in big law, Jeremy represents businesses of all types and sizes and counsels companies throughout their life cycles, often through ownership exit. He counsels privately held middle market and emerging growth companies, family offices, funds, C-level executives, boards of directors, family-owned businesses, and entrepreneurs in a myriad of M&A, financing, and other commercial matters. I am your moderator, Robert London. I'm a partner at the full-service law firm of Jaspin, Schlesinger, Narendran, which is a full-service law firm in Garden City, New York, a stone's throw away from Manhattan. I basically hold myself out as a transactional attorney. Basically anything that's tough to negotiate and easy to draft. Nope, that's not true. It's the opposite around. If anything, the fun is negotiating a deal, getting a yes, and handling with the complex drafting. I've been doing it for a long time, and I feel the value add is that of a business conciliary as well. You'll like us. You're going to have a good time today, but you don't have to listen to our infomercials. If you're interested in more about us, you can go to our bios at the back of the PowerPoint. This webinar is a production of Financial Poise. More about Financial Poise can be found on slide 40 of the deck. If you're attending the live premiere of this webinar, you could submit questions using the web portal. If you're watching or listening to this on demand, or you have any questions after the webinar, you can send an email to info@financialpoise.com. Now for some of the important stuff. Remember, the PowerPoint conversation we're about to have are meant for general educational purposes and that is not replace the need to consult with an attorney, accountant, or other appropriate professional. In other words, if you're silly enough to take significant action based on what you learn or hear here today, then don't blame us, and please lose the deck with our bios if things don't work out the way that you want. Once again, thank you to our sponsors. You can see information about today's sponsors on slides 3 and 4 of the deck. Okay, let's get this party started. I sort of retooled this webinar. In years past, there was a lot more talking on isolated topics and a lot less negotiating. So this year we've pumped up the negotiations. So you're going to hear a bunch of mock negotiations. There are going to be no winners or losers of these negotiations. If anything, in my informal discussions with the panelists in advance of this webinar, we've made it clear that these mock negotiations are really more to give you an idea of what the deal points are and what some of the solutions are. So even though there might be a line on your betting app as to who might win these negotiations, good luck collecting them because they're not real negotiations. So we're going to start with a couple of basics to set the stage for some of our mock negotiations. And I'd like to start with a general short discussion to set the stage. Many mergers and acquisition transactions negotiating points are colored by the types of buyers that are involved. Tom, can you set the stage for that regard? Can you give us a
Sure,
little
I'd be
background?
glad to. And so the buyers, it really can depend on if they're like industry competitors to the company that are going to just kind of take over the company and merge it into them, or maybe a private equity fund that's looking to make a platform out of the company and is going to do other mergers, or it could be a family office that has long-term plans and is not looking to turn the company over in certain years, or it could be a ESOP, which is like an employee ownership. So it depends like what the objectives are on the buyer. If they're looking to kind of just buy it as is, if they're looking long term, it's going to also depend whether the seller is going to be involved with the business or not. So that's kind of a brief answer, but it's very important for negotiations to know the intention and objective of your buyers.
All right, I'm going to hop over to Mike before noting that if many buyers bought companies as is, we probably couldn't afford to be on this webinar. So not typically advised, but sometimes in fact done. Michael, let's finish fleshing out our background. Let's talk about how deal structure can color negotiating topics and points.
One of the first decisions in a transaction after a buyer gets interested and a seller gets interested, and they're interested in working together, they often turn to the accountants and the lawyers and say, hey, how should we structure this? Should this be an asset deal, or should this be an equity deal? We used to say stock deal, but now there's so many LLCs that equity can be in different forms, stock or membership interests. And in that decision on deal structure boils down to a few issues. It's beyond the scope of this uh, webinar to really talk about tax issues or too deeply, but tax issues are a big driver. Buyers generally like to buy assets because they don't want to take on any liabilities, and they get a step up in basis, which is a good thing from a tax standpoint, depending on the types of the company. Sellers generally like the opposite. They would like to just sell the stock. That's easy. They get more favorable tax treatment. So there's an analysis of tax and financial reasons as to whether to do an asset deal or a stock deal. And sometimes I think I've been doing more equity deals lately. They are easier. And often if you're selling a business where there's a regulatory scheme where it would just take a buyer either too long to comply to get a license or to get permission to run the business, whatever that permission may look like, often we'll do a stock deal just because it's sort of quicker and easier. Or if there's any specialized contracts that need to be done with the buyer entity, we'll often do a stock deal. But there's a lot of up and back and a lot of analysis and number crunching done in the beginning regarding whether it should be a stock deal or an asset deal, and it never fails. And both very sophisticated transactions and non-sophisticated transactions. We're always seem to be looking at that analysis, and each side sort of has some arguments and points, and hopefully a consensus gets reached on that, which it usually does, and the deal moves forward either as an asset deal or a equity deal.
All right, let's have Bob chime in as to how deal points might be affected as to whether or not the seller is going to be continuing on in the business that it sells in some capacity or simply exiting. And Bob?
Yeah, so if a seller is not going to continue with the business as part of the ongoing management team, inevitably the buyer will want to have the seller sign a non-disclosure agreement and a non-compete agreement. More importantly, typically these non-compete agreements could range from 2 to 5 years, though I have seen some go longer than that. And essentially, the buyer does not want them taking all of the industry information, company information, and setting up a new competitor. Sometimes a seller will spend a period of time doing a transition to a new management team, but typically there will still be a non-compete in place. And actually, a portion of the purchase price can be allocated to the non-compete, which can be a consideration for tax purposes.
Thanks very much. Jeremy, time to join the party. Before we get into purchase price, and we are going to get into purchase price, what are some of the strictly non-financial covenants that need to be negotiated as a part of the deal other than showing the money?
Sure. So Bob touched on a major one, which is the restrictive covenants, non-competes, non-solicits, that sort of thing, meaning how long is the seller precluded from competing with the business, starting a new business, all those sorts of things. The other thing implicated by your prior question to Bob was, staying on or not in the business. And so that naturally, goes to items such as a consulting agreement or employment agreement. If somebody's going to stay on long-term, then obviously it's just like any other employee. If it's going to be some kind of transition event where the seller is going to stay on for 1, 3, 6 months, then it's maybe a shorter term, usually in the form of a consulting agreement. The other types of things are things like transition services. So say you have a bunch of outstanding accounts receivable. What is the process for collecting that? Is one party going to do it on behalf of the other? If so, you may have something called a transition services agreement. Other items are things like real estate. Let's say you have a manufacturing facility and the seller owns the property upon which the plant is located. Is that real estate getting sold with the business? Or does the seller, who was also the operator of the business before the closing, does he continue to own or continue to own the real estate and the buyer is now a tenant? So there's lots of things like that don't directly go to purchase price, but that are major, kind of transaction items to figure out between the parties.
Great. Thanks. Let's say, Tom.
Yeah.
You're at the McDonald's of purchase price, and you stare up at the menu to figure out to make your purchase price meal. What are the various menu items? What can comprise the various types of selections that you might in structuring your purchase price? Bearing in mind, we are going to shortly get into a discussion of and a negotiation of those points.
Well, this is a very important topic to myself. I'm sure Bob, as an investment banker, because we want to get paid on what the price is. And so some things are quite obvious, and that would be like cash up front, or it could be it could be an earn out later of things that are going to come in later. It could be stock in the company. It could be that it's broken up into stages. So there's a lot of different ways, but some things are a little bit less obvious that are also purchase price. Let's say, for instance, like, Jeremy was just talking about, real estate, where the owner owns the real estate. let's say that they cut a deal to pay double the normal rent. In a sense, that's proceeds. Or let's say that the company, instead of selling 100%, leaves behind a lot of assets. That might be considered proceeds too, or assume certain liabilities that the company owed. That could also be. So it's not such a straightforward question, but it's anything that really brings value to the buyer in except, let's say they're going to have a contract to work, as Jeremy was talking about, but they're paying them like 3 times what's a normal price. In a sense, that's purchase price above the norm that they would be paid for that work.
Okay. Let's touch on purchase price now. I'll tap Bob, which is, how does an advisor or a seller or even a buyer in looking at a company derive purchase price to make that first offer? Is there a book of purchase prices available, hiding in a cave that Indiana Jones finds? What generally, how does one arrive at purchase price?
Yeah. So the most common measure today, and presumably the most objective, not always, but is when people pay a multiple of EBITDA, earnings before interest, taxes, depreciation, and amortization, which is a approximation for the cash flow of the business, excluding future capital expenditures on the business. There are instances where EBITDA is not the appropriate measure for buying a company. It could be a company that has negative EBITDA, either because it's distressed or it's perhaps in a fast-growing, very, very high growth mode, where they're spending a lot at the operating expense level. And in those instances, sometimes a multiple of revenue can be an appropriate measure. But the other things that come into play for deciding these things, what's the right EBITDA multiple? You certainly want to look at transactions that have been done in the industry. You want to look at maybe some public comparable public comps, where what are these companies trading for in the public markets? And then beyond just, sort of the EBITDA or revenue multiple, there are a lot of other factors that come into play, such as what are the projections of the company? How quickly is the industry growing? How much green space is out there? What is the size of the entire market? What are the gross margins of the target? Those are super important. Are there any synergistic cost savings available perhaps for a strategic buyer? What sort of intellectual property is available in there? Are the assets worth more than what the projected EBIT does? So maybe there's real estate involved. So all those considerations are other factors that come into play that go beyond just, a straight EBITDA measure.
I would add to that, Bob, that it's kind of a two-step thing for a buyer to determine what purchase price they're going to offer. So the first thing they're going to want to do is figure, forgetting the multiples, what is this company worth to us? So if we were to add it to our company and we can project this type of future cash flow, and then our personal discount rate is this, and we're going to say it's worth, let's say, 70 million. So it's worth that to us, taking into account like the synergy. But then they're going to say, okay, what should we offer? And so then they look at those things like EBITDA multiple, and they go, well, like 10 is kind of standard, and it's 6, so we could offer 60, but we don't think there's any competition, so we're going to offer 50. So they figure what it's worth to them, and then they try to figure what they can get the company for. So it's kind of a two-stage thing in a sense.
And one thing that I'll overlay on top of that, and Bob and Tom may smack me the next time they see me, but buying a business where you're outside of the, let's call it PE space, is very much like buying a house, right? Somebody looks at a house at the end of the block and they go, I would never buy that house because it's right by the major street. Somebody else looks at it and goes, you know what, I'd love that house because that lets me to get right on the road and quicker to work and get home. And so there absolutely is an element of purchase price that is non-measurable, purely subjective. And I think, a lot of people get stuck on this. Well, it's, X times EBITDA or Y times trailing 12 months. And yes, that absolutely is a thing. It's used a lot, but it's not the exclusive measure, because one person's trash is another person's treasure. And it's
Totally
actually the
agree.
same thing with a business.
Yep, good points.
All right, so let's pretend that Jeremy and Michael on behalf of the buy side and Jeremy on behalf of the sell side have been locked in mortal combat for weeks and have finally gotten to yes on purchase price and payment method. But now Michael, has to sort of take the laboring oar in putting the pen to the balance of the things that go into a letter of intent. Michael, let's start with telling Jeremy from the buy side that other types of things other than purchase price related that you need to cover in your LOI, and then Jeremy can kind of respond with his feelings on your feelings.
Sure. From a buy side, and we're talking at the LOI stage at this point. And let me set the stage to a certain extent. It's a very, I think all the panelists would agree that it's a very competitive market for deals. When a good company comes on market for sale that's fairly priced and fairly valued, there's a lot of buyers out there, and there's a lot of capital to do those acquisitions. I mean, I think there's no question. There's a lot of PEs, and there's a lot of synergistic buyers and industry buyers. So as a buyer, you generally have to move real quick because often it's in somewhat of an auction process is being created. So as a buyer and representing a lot of buyers, my buyers always, now their legal counsel, they want to go fast. Let's get that LOI out in a day or 2 days. And the buyers don't really know much about the company. So an important thing from the buy side is some period of time for due diligence. Hey, here's what we're thinking as far as value. And presumably my clients on the buy side will throw out a number that the seller will like. If they're not within the ballpark, they're not going to go anywhere. But let's say it's a good number, they wanna do it, and they do it quickly. It's very, very important. And from my accounting standpoint too, and my auditing standpoint, the due diligence I think is incredibly important. And from the buy side, I want a period of due diligence so I can really dive into the financial statements and other aspects of the business and really understand what I'm buying, because I got that LOI out real quickly, because the seller was sort of putting on pressure and there's a lot of interest. So I want the ability to analyze the business. So I would say that's for and I also want time to analyze what the structure could be, whether it's a stock deal or an asset deal. And I also want, of course, some type of exclusivity, because I'm going to be spending time on the business and evaluating the business. So I want to make sure the business is off the market and I'm the only suitor there. So in my LOI, there'll be exclusivity, a period for due diligence, and confidentiality, because I don't think neither the seller nor the buyer wants the public to know, or wants the employees or anybody to know that people are talking about a transaction.
Okay, so now I get to be the seller's position. All right, Michael, that I get it. You're going to be spending some time and money and energy, but I have 17 suitors that want to buy my client's company. I need to get something from you if I'm gonna agree to take myself off the market from these 16 other potential suitors. I needed a deposit from you, and in fact, I need it to be a non-refundable deposit. If it ends up, that there's fraud or something, fine, we'll give it back. But absent that, if you're asking me to stay off the market for 30 or 60 days and I'm not getting a binding commitment from you, I want your client to pony up and give us something to essentially pay us for efforts. In addition, the other thing I need from your client is to not solicit my people. So, I'm going to introduce you to my high-level people so that you can get the information you need. But I don't want you to, go through this 60-day period, decide you don't want to buy me, and now you're plucking all my top salespeople or my top executives. So I'm going to need you to agree to some non-solicitation clauses in the process.
My response would be the non-solicitation, no problem. Yeah, done. And I would say rather than a response, I would agree with and going to the side of the negotiation now. There's always a fair amount of discussion in my world about non-refundable deposits and the costs. And I'm curious where others end up. Where I typically end up is that there's usually no non-refundable deposit. It's sort of a risk that the seller has to take normally. Sometimes there is, and then the buyer sometimes would negotiate and say, "Hey, I also want some type of payment if I go down the path and I see, wait, this company has all these problems you didn't initially disclose. So to use Tom's number of 70 million, I don't think this is worth 70 million. This is worth 30 million because you sort of represented, that I would see A, B, and C, and I'm not seeing D, E, and F. So there's some up and back that goes on there, and sometimes there is some sort of breakup fee or deposit for expenses, because I think all of us would agree the evaluation of a deal from the buy side and the seller's time and expense dealing with that buyer with professional fees and so forth, they all add up, and more deals fail initially than close. So it shouldn't be treaded. It should be treaded very carefully. There's a lot of expense involved. But Jeremy, I'm going to decline. I mean, we're real. We'll go quick. We're going to be spending our own money. So we'll go as fast as possible, but we're not going to give you, anything non-refundable.
I'll play the summer associate in the room who just heard that and whispers, "Oh, what if diligence is taking longer? Should you have the right to extend?" How about that, guys? How often does that come up? And what hurdle, if any, needs to be met to get that extension?
Yeah.
So-
Let me tackle that one first, and then everybody, because we see that all the time. When I'm representing sellers, I know all sellers like a drop dead date, because a buyer, from seller's perspective, a buyer can keep asking for more information, more information, more information. It's almost like you can never hit the end. So when I represent sellers, I don't like an automatic right to extend. I want to talk about it and see what's going on. Are they just stalling? Is it really sort of a fake excuse that they don't have their financing lined up? So I really want to understand where we are in the transaction. So others may disagree, but I'm not a big fan when I'm on the seller of an automatic extension. When I'm on the buy side, generally buyers would love all the extensions they can get.
Yeah, I mean, this is one that absolutely comes down to negotiation, leverage, and the circumstances of the transaction. Again, if you're dealing with the really hot seller that has 17 suitors, that seller's probably going to be able to get a no extension. Because if there's no deposit, there's no, the automatic extensions, they're going to take a pass. I mean, unless the purchase price is so beyond what they expected. All these things come in as part of the calculation. But, typically speaking on something like an automatic extension, like what Michael said, I'm a no on that if I'm representing a seller. What I typically see and where things typically end up is, a good faith criteria. If the parties are negotiating in good faith and continuing to work towards a closing, that exclusivity period will get extended. And look, I mean, absolutely games can get played, and yes, buyers can make 47 diligence requests. You see that all the time. But if it's genuinely tied towards understanding the business and getting to closing, that's the kind of price of going through a process if you're a seller. So it really comes down to negotiation leverage. If there is somebody else waiting in the wings, then, a seller can say no, right? And you agree to your 30, 45, or 60 days or whatever it is, and then you move on with life. But it's absolutely a bargaining position. And if parties are acting in good faith, typically you see those extensions, almost routinely. But if somebody's acting in good faith or just stalling. The one other thing I'll say, and I know Rob's itching to move on.
Yeah.
He took himself off mute. Is that, the other provision I like to put in for a seller is if at the point that the buyer says they're not going to pursue the transaction anymore, or they're not, moving forward in good faith, then even if there is a set exclusivity period, I look to have it terminated, by its terms. So just one other thing to consider.
Okay, so like,
Let me just throw one other thing in here. We were talking about non-refundable deposits, and most of the time you don't get those. But the one time where that is probably appropriate is when you have two competitors in the industry, one buying another, and just to make sure that they aren't coming in and tire kicking and trying to get a bunch of information and walking away from the deal. In those instances, a non-refundable deposit would certainly be appropriate to ask for.
great. All right, so a little while ago, thanks to Tom's Happy Meal, we got an idea of what the purchase price pieces of our meal look like. And I'm going to invite now Tom and Bob to have a short mock negotiation how gross purchase price is going to be divvied up as among cash due at closing, an escrow, seller note. We'll take the situation of a private stock deal with a strategic buyer. Tom will take the buy side and Bob will take the sell side.
Sure. Well, Bob, we're excited to buy the company, and I know you guys have represented to us just how valuable it is. And given the uncertainty of the past years and the fluctuation, and we're optimistic, and so we're going to offer you a better deal. We think it's better if we don't give cash at closing, but we're going to give you an interest in the entity, and we're going to give you an earnout so that you could actually earn more if the company performs as good as you've been saying. We are going to need to put a pretty good percentage of 20% into an escrow because we're concerned about violations of the reps and warranties and other non-competes, and so we're going to need to have part of the purchase price. And we also appreciate you guys are making out real well on this, that you can offer us to get this deal done quick, a seller note for 50% of the purchase price. So if you can just agree to all these things, we could probably be done this afternoon.
I would quote Dan Aykroyd and say, Tom, you ignorant, but Tom, what my seller is really looking for here is cash. Look, you're a strategic buyer. When you're allocating a portion of the purchase price to an earnout, I may or may not have any control over, what the ability of that business to make money will be going forward. You're more responsible for that than I am. So trying to put a bunch of purchase price on the earnout really isn't going to fly with a strategic buyer. Now, if I was in running the business completely and you weren't allocating any cost over here, maybe we could think about a small portion of that. But listen, a seller note may be appropriate to plug a gap between the cash and what financing is available. And at least I know what I'm getting from that seller note. And as long as you put a reasonable interest rate on that, I'm willing to leave a seller note in place for maybe 2 to 3 years. 20% escrow is not going to fly. You guys can go do all your due diligence items. You know, we'd be willing to agree to a 10% escrow. We're not aware of any contingent liabilities out there. And so 20% just isn't appropriate. But in this case, you know, the balance, most of the purchase price here should be in cash. We could have some in a seller note and then, you know, a modest but sort of market amount held back on the escrow.
Well, I appreciate and you make some good points. I think as far as the escrow goes, we don't want to go as low as 10, but what we could do is have part of the escrow at 15%, and at 6 months, if nothing's happened, you can take that 5% back. If nothing happens at a year, another 5%. As far as the earn out, you make a good point that you don't have control anymore, but you know, again, we're going to do so what we could do is base it on an objective criteria that we both agree to that's an industry standard. And if that's hit, then we know that the, you know, because this is a very cyclical business. So if we can kind of create an objective framework, but we can sensitive to what you're saying as far as the seller note, but that's going to be important to us. And we can negotiate with you an interest rate that will be attractive and give you liens on the business. So if something were to happen, you could take that back.
Well, if we could find, we believe in this business going forward, and if you are keeping us on and we're very active in the business, and we can find a very objective measure for an earnout, we'd be willing to take somewhere between 10 and 20% of our total consideration there on the earnout on top of everything else.
We're going to be headed to a mock negotiation of earnout shortly, but while I have Bob and Tom, I'd kind of like to ask them, when we're dealing with the cash portion and we're dealing with a note and perhaps an earnout, you know, let's say that there's a newco that's been brought in to buy, you know, to buy the company. It's a stock deal, for example.
Mm-hmm.
How often do you see parent guarantees? And I know that we were floating around an escrow and a seller note and an earnout.
Mm-hmm.
How often is a part of your buyer's comfort package and the seller's resistance to that, are those factors thrown into an indemnification negotiation, which if we have time, we'll get there too, but those are all sort of moving parts to the whole process. You can both sort of chime in agnostic as to buyer seller sign, just to educate.
Yeah. Well, absolutely. If a new entity is being created, that entity might have no creditworthiness or no value. So it's very important for the sellers, if the buyer's coming in, that, you know, there is some type of, you know, some collateral that they can get at that if something were to, you know, go wrong. So they're not just negotiating with like a paper tiger.
Well, and I guess from a seller standpoint, I want some assurances that that seller note is going to be paid, and so want something creditworthy behind that, and would, for the most part, insist on some sort of guarantee from the parent company on that portion of the purchase price.
And I'll chime in there too. I mean, this idea of having the business that you sold or the stock that you sold as being collateral for the note is clever and fun, but the circumstance where the note's not going to be paid, how much is the business then really worth? And second, just from I'll say from the legal transactional side, getting the deal done, a lot of parties don't have the tolerance for now doing the security documents, making the filings, figuring out whether or not the security interest is going to be subordinated to any senior loan, intercreditor agreement. So I find it's clever and it's right, but I'll throw it out to anyone else sitting around our campfire. How practical is it really?
I would chime in, Rob. I would say it's more practical in my world than you think, and that's what makes these transactions all complicated. Yeah, at a certain point now, a seller is a lender, and how are they going to get paid? And there's a little bit of underwriting. So in transactions, and I'm curious about everybody, that aspect becomes very important. I agree, people get fatigued, and people, you've got already 40 documents in the deal, but I still see the hoops being jumped through to get the security for notes and underwriting and so forth. Curious what others.
Well, one of the things the seller is going to want to know is how is this business being financed? And if a buyer is coming in with 70% leverage, 30% equity, and also insisting on a seller note making up some portion of that 70%, that's a pretty highly leveraged deal. And so that makes that seller note much riskier, which is almost always subordinated to other financing in there. So in those instances, I think I'd be either looking for some sort of credit enhancement from a parent, or else trying to minimize the amount of that seller note and providing for, in the senior loan documents, the ability to pay that out, provided that you're hitting certain earnings measures.
Follow on for Bob on that, which is, if we're really concerned about the seller note, how typical would it be for the seller to be able to get a limitation on further indebtedness in that seller note?
That's a tough one.
It's a tough one. I agree.
Well,
Yeah.
it's one of those scenarios really where you almost have to look at, and I know you said, Rob, we were going to get to an earnout discussion in a minute, but it's the same kind of thing where if that note ended up, being worth zero, is the seller okay with doing the deal? Right. And this comes back to where, is this the single buyer and do I need to get out, or do I have 17 buyers and really don't have to get out? And so if that's the offer on the table, if you will, right, how strong is it of an offer is it? And as a seller, is that a risk you're willing to assume? And yes, there's ways to minimize it. You secure, you make it secure, you get a guarantee. At the end of the day, you're sitting on a piece of paper. And do you want to have to sue to enforce it if they don't pay it? And is there anybody to recover against if they don't pay it? So, it's one of those analysis where you got to look at what's the likelihood of getting paid and what are the mechanics of getting paid. And if both of those are low, then as a seller, are you going to accept the cash you get at close as being an acceptable purchase price?
All right, let's move along, because there are at least 3 more negotiations I'd like to try to get us to in our remaining time. And it is earnout negotiation time. Michael, you take the buy side. Jeremy, you take the sell side. Let's negotiate a few deal points which might arise when the buyer requests an earnout.
All right, I'll go first as the buyer, up against Jeremy again, who's a tough negotiator. So I'm on the buy side. I'm making a good offer for the business. But Jeremy, I do want to pay 20-25%, let's say, as far as an earnout. A high percentage of your business derives from 2 or 3 key clients. And I noticed those clients have been good, but there's some, rumors floating around that there may be some regulatory changes, post-election that may affect the amount of business you get, this company's going to get. And if business drops significantly, boy, my purchase price that I'm paying is just really not making a lot of sense. And if it doesn't drop, I get it. So let's take, 25%, put in some metrics and milestones. And if those metrics are are hit, I, as the buyer, will gladly pen those checks to you. But it's too risky. You want full value. I want the company. So work with me a little bit. Let's sort of meet in the middle here, and let's take a little risk with me.
But Michael, here's the issue, right? My client is out of the business. How do I know that your guy is gonna really try for these accounts, or if he's gonna look at it and go, not worth my time and hassle, especially since I got to pay Jeremy's client, whatever cents on the dollar. How do I protect against your client moving this business to another company or a related matter? You didn't say specifically what you're going to pay me on, but maybe I can get behind something when you're talking about a gross revenue. I'm not going to, have my client go to battle about a definition of net income and an allocation of overhead, and this is all out of my client's control, right? So if your client will agree to a gross revenue figure, right, which is X dollars come in, that's what we're going to base it on. And at a minimum, I'm going to need some good faith covenants, good faith and fair dealing covenants. I'm going to want to see your budget post-closing if you're going to try and hit me with any costs. Maybe we get around that with a gross figure instead of a net figure. But I need this to be an objective measurement that I know my client, if it happens, is going to get paid. I understand your concern about, what might happen post-election or post new administration. But I can't be my client can't be having to chase you for these amounts if they're genuinely earned.
See, I told you Jeremy was, such a good negotiator. Jeremy, you make a lot of good points. And wink, wink. I think if I were sitting in your chair, which I often am, I would make the same points. I think that's fair. And sort of echoing what Jeremy said, when you're on the sell side, sellers don't love earnouts. They want it to be tied to a revenue figure rather than a gross income figure where folks can kind of fudge the numbers, for lack of a better term. So yes, I will agree to that, and I'll agree to good faith and fair dealing, because the more money that the company does and the more sales is certainly good for the earnout, but it's good for us too. So you make some good points. I agree with you. Let's get it drafted and let's move on.
I find sometimes as that sellers don't like earnouts because they can't control it. But like what I find that sometimes a good compromise is to get, especially if a new entity is being created to acquire the company, is to take like stock in the company or have it based off of hitting some return on investment. And then everybody, it's pure pursue, it's the same, and then everybody then is in the same direction, because these earnouts, even if you have a revenue one, that can be skewed because, their businesses aren't in the business of making revenue. Some revenue is worth a lot and some's worth nothing. So I find basically kind of tying the, on a return on investment that really kind of bridges the gap.
The other nuance is, if you can get, if the seller is sticking around, right, and this earnout is based on the performance of, let's say, the division that the seller is going to be running, then it becomes, to Tom's point, right, everybody's rowing in the same direction, right? Everybody has an interest in hitting those numbers and then some, because it directly benefits everybody financially and otherwise. So that it's a different situation there, where there is that element of control that remains.
Yeah, but then, from as like a lot of, it's risky though, because so often people are promised positions and so often it doesn't work out for one reason or another. So it's like, you can't be guaranteed you're going to be in that spot for even the full year.
The one thing I might add to that, at least wearing my sell side hat there, is that whatever the metric is going to be, you want to try, if you can get the buyer to track financially the purchase business on a standalone basis, so that you get some reports that at least look vaguely familiar to your own financial reporting while you own the keys to the car. I'm going to move us along because I'd like to see if we can sneak in 2 more negotiations. But right now I want to jump over to Tom and Jeremy having a mock negotiation on representation and warranty survival, which are sort of the keys many times to an indemnity claim. Tom, you take the buy side, and Jeremy, you take the sell side, and let's negotiate representations and warranty survival.
Okay. So these warranties and stuff you're making are very important, and I think they should, there's no reason I see that they shouldn't just survive perpetually. Because if something were to happen that all of a sudden we have some lawsuit from something that happened when you guys were owning the company and it doesn't show up for 6 years, I don't want to be responsible for that. Was your problem. And so to do this deal, we really, and you shouldn't have a problem with making your reps and you're standing by them. So, we don't want to have a clock ticking on them because who knows when they'll come up.
Tom, I got a wife and 3 kids that I'm using to support here. At some point, I need to know that the money I'm getting in this transaction is mine to keep, right? So yes, if things come up in the next little bit here, I'm happy to stand behind them. But listen, I've talked to my buddy and he only gave 6 months. But I'll be a good guy here, and I'll tell you what, I'll give you 12 months reps and warranty. That I'll stand behind it for 12 months. And look, my business has been really clean for all these years. There's nothing there. But I need to know at the end of the day that I'm walking away so I can take my wife and kids to Disney.
Well, I appreciate what the wife. I think 1 year. Let's make it tied to when your first audit's going to come out, which is going to be 14 months, so we can at least have an objective. And I appreciate you want to take them down to Disney, but I've seen your client has been a little bit lazy on their on their pollution and then and I'm very worried about environmental, and that can. So I'd like that one to set out that survives at least as long as the statute of limitation.
I can't give you both, Tom. I can give you one or the other. I can either give you an audit cycle, or if you're that concerned about the environmental, I can tell you I was out there myself digging. There's nothing there, but I'll give you one or the other.
How about you give me a phase 2 then?
If you want to pay for it, I'm happy to have a phase 2.
Good response. I'll pay for it as long as I don't find anything.
Just to weigh in briefly, I think what Tom and Jeremy did a great job of highlighting is different reps and warranties in the M&A transaction are, I don't want to say more important, but are either more important or harder to find and take longer. So in the M&A world, we have these what we call fundamentals and non-fundamentals, and some things last longer than other things. So it's a negotiation of, and the seller's argument is, hey, the buyer's done due diligence. They should know everything. There's a little bit of risk, and the seller's argument is but usually there's some sort of bifurcation between fundamental and not fundamental, and the fundamentals last longer, and those are the big ticket items.
Those are a good point. I also want to we're talking about negotiation, and these reps and warranty really are often come up at the very end of the deal. And everybody's been working on the deal for like 9 months sometimes, and people are getting really tired. And these reps and warranties are like bringing up, we like to say, a parade of horribles. Things that nobody thinks is going to happen, but possibly could happen. And so what happens is nobody wants to be responsible, and people are starting to get tired. Now, rep and warranty insurance has come into the and it's taken out some of this, but it's only in particular deals where it really works. So in like lower middle market deals, it doesn't apply. So I find these rep and warranty a lot of times can be deal killers, because what ends up happening a lot at a deal is people are getting fatigued and feeling like they're giving everything, and the other side's feeling they're giving everything. It ends up in brinksmanship. And they can be deal killers. And so that's why having professional and experienced lawyers like Jeremy and Michael and Robert and Bob and myself as investment bank, like, they can kind of get the parties through these things, because the parties just, I don't want to have that 50 million environmental live, nobody, and they're just like, screw it, and the whole deal can break up. So these, even though they're small, are really important for getting deals past the finish line.
In getting the deal past the finish line, I mean, the clients have to recognize that counsel's job and advisor's job is to protect them. And the best case scenario is they get protected, but no one ever has to look at the contract again. And as people get deal fatigue, especially on these types of things, there are ways to sometimes get around it, because there are private, there are surveys available as to what is survival on environmental these days, what is survival on, what is perpetual survival, what's market for general reps and warranties. So if you do get to deal fatigue at the risk of losing the deal, you may say, all right, let's take a look at the survey, let's split the baby. You don't want to kill the deal over it, but at the same time, you want to have a document that protects them, that hopefully you never have to look at again, because there's not an issue.
I find also that these deals can sometimes go back and forth and a redraft, and it's 3 days here and it's 3 days here, and sometimes at a certain point you got to get everybody in the room. Maybe today it's a Zoom meet. It still would be nice to have them physically together, but sometimes these deals, because it just drip, your whole deal. So sometimes it's still, you got to go back to the basics and get everybody to kind of come together, and you can accomplish sometimes in about 6 hours what takes 3 weeks.
The other thing is, it's interesting. We're talking about negotiation strategies. When you get into these deal fatigue scenarios, which are absolutely real, no question about it, it's amazing how much ground could be gained or lost when you're in that. So as an advisor to a client, when they're like, fine, just give them whatever they want, I just want to be done with this. That's when, all of us on this panel make our money, right? Because that's where we say to the client, I understand, but here's what you're giving up by doing that, right? So you can do that if that's really what you want to do, but understand this, right? And you may have been going, as Tom said, for 9 months, battling tooth and nail about the smallest and most, remote possibilities. And now there's something that really is there. Maybe there is an environmental issue that's on the table, and you say, fine, I'll take it, right? And now you've just taken on a major liability risk that maybe it's fair, maybe it's not, depending on the circumstances. So it's really when it's important for the advisors to be good advisors to their clients. But yes, to Tom's point, you get people in a room at that stage where there's 6 or 8 or 10 major remaining issues, and you figure out how to get through it.
And this is where emotional intelligence, and I think Bob's ready to wrap it up, but this is where, really understanding what matters to the other side and what doesn't. So there's sometimes things that one side just cannot give on. Like, it might just be their corporate policy in their German headquarters is, we cannot do an environmental contingency. And so you have to understand where people are going and really bring them together and be able to kind of talk on the side with parties and kind of understand what they want. And that's really the key to getting a deal done, is to understand the other side as well as your side.
I think the number one item in our advisor tool belt, other than patience, is the open issues list, circulated in advance of any negotiation. So you can see them, and at least you can have a sense from your side what they're willing to give on and stuff. Having an agenda before any of these meetings or calls, or even having those hashed out before the next turn of the documents, because people don't have patience for multiple red lines is the way to go. I think we're out of time. I'm glad we hit most of the negotiations I wanted to. Thanks to our great panel. This was a fun one. This is, as I said, the dream team here. Happy holidays to everyone. You can look for me and other talented panelists like we have here today. Again, in 2025, I think I'll be starting with a 4-part series on startups, and I'll be returning to host the 5-part series on private M&A in 2025. Happy holidays. Stay safe, everyone. Have a great
Thank you.
day. Thanks again to the panelists.
Thank you.
Bye-bye.